Hello, everyone. My name is Josh Gilliland, attorney blogger on Bowtie Law, and with Jessica Meterson on The Legal Geeks. Thank you for joining us today to discuss international eDiscovery. With me today are my friends from Planet Data and Exigent Group in Ireland. I believe David's in, and we're going to have a great time discussing eDiscovery, international ramifications, and how Planet Data and Exigent are working together. So with that, Howard, how are you today?
I'm fine. Nice to see you again, Josh.
Wonderful. And David Holme, welcome. First time that we've done a podcast together. How's the great country of Ireland?
Well, thanks, Josh. I'm actually not in Ireland. I'm in London today. So our data is actually is hosted in Ireland, but I'm currently in London, which is our sort of head office. But thank you for letting us join.
Thank you. And David Cochran, how are you?
Doing great, Josh. Good to speak to you again.
You too. It's been too long. Well, let's talk about international eDiscovery, which has all kinds of strange issues and permutations. And before the call, Howard and I were talking about one of the recent eDiscovery cases that just came out. And Howard, why don't you give everyone an update on what just happened in New York?
Well, there's a case involving Microsoft, and about 6 months ago, magistrate judge in New York had ruled, it was a criminal case. They were doing an investigation, and there was a search warrant issued by the U.S. government for requests for data that Microsoft had under its control, but was sitting in the cloud in a server in Ireland. And so the issue here was whether U.S. jurisdiction would extend to data outside of the United States, but controlled by a U.S. entity. Judge Francis, as the magistrate judge, ruled against Microsoft, who then appealed, and then yesterday, the U.S. District Court judge in the Southern District of New York upheld Judge Francis's decision, of which Microsoft and many other corporations were against, and well, I guess they're now appealing to the U.S. Court of Appeals. But for now, the judge has stayed any execution of the warrant. But of course, it raises a lot of cross-border data storage, cloud-based issues about where data resides and if it's subject to U.S. jurisdiction.
So David Holme, when you hear a case like this coming out of the United States, what's generally a European reaction to such a court order?
I mean, bear in mind we work out of Australia, Canada, and Europe as well. I think, I read about that case earlier, actually, by coincidence. I guess my first reaction is it's pretty terrifying, actually, because it's taking the reach of US jurisdiction to another level. When I speak to clients, about some of the things that we're doing in the States, who reside outside the States, their concern is how far this reach from US jurisdiction will go. And I suppose just from a sort of global perspective, it's surprising to me that the US wants. It's almost like it's constricting the US sort of industry, really. Which is, when you look at what sort of the discovery partners like Planet Data are capable of doing in terms of the analysis and processing and so forth, the capability is far ahead of the rest of the world, no doubt about that. It just amazes me and shocks me that this reach has been taken to another level and has a big impact on the strategy for the cloud, I think.
It could also have a negative impact on business for a variety of reasons, in my view, because of the interconnectedness that we have, and that you can have a company in Florida place an order for someone in France, and production of the items would take place in China. It can all be done in a matter of seconds, and it's spanning the entire globe. I'm not sure if these type of orders would encourage people to do everything locally and be a deterrent to international business, which I don't think anyone really wants to happen.
Well, I think it's the law of unintended consequences, isn't it?
Yeah, I don't think they're not planning that.
No, I think that's absolutely right. But this has always been the example that I'm talked to constantly in Canada and Europe, which is a judge in the second district of Texas or wherever presents a threat to us and the way we do business, and that's a problem. And if you look at what this ruling says, it's talking about the fact that it's talking about the cloud, it's talking about Microsoft as effectively a host, and that's not what they're trying to do. Really, they're not involved in the transaction in any meaningful way, and that's pretty interesting development, I think. What's your view on whether it's going to stand? I mean, I know it's impossible to say, but is there anybody on this call that's got any sense of whether this is kind of out there or not?
That's a tough one to answer. There were some cases within the last 5 years that I remember where the plaintiff in the lawsuit was based in Utah in the United States, and the other party was based in Germany. And because of the business between the two, the courts took the point of view, just can't hide everything in Germany. Therefore, you're going to have to produce this information as well. There were a couple other opinions in the case where the party in Germany was doing some really underhanded things. They produced all native files they printed everything and then rescanned it as non-searchable TIFFs and then dumped it on the requesting party and said, this is a reasonably useful form. So they did some things that really aggravated the judge, which did not endear them to their position. So discovery conduct does weigh heavily on this. But with this one in New York, I don't have a crystal ball. I don't know the court there. Howard, do you have any thoughts on this?
I actually, shockingly, I do. I know you're surprised that I might have a comment. I think that, as we know, it's difficult. The Court of Appeals doesn't overturn many decisions. But in this case, let's keep note of something here. This is really can be designated. If I'm the court, I'm thinking of a way to both uphold this, but also grease the skids for commerce and not put a chilling effect on the ability to store data around the world and move commerce among the EU and the United States. And this is a criminal case, okay? And while both the citizenship and the location of the defendant is not identified, it is basically this is a search warrant, okay, in a criminal case, and the feeling from the commentators is probably a drug case. So you could carve this out and say, look, we don't want the bad guys to be able to store their data outside the U.S. and have it outside commit a crime in the U.S. and then have the information be outside the reach of U.S. jurisdiction, but we can make this an exception. This is not going to be the rule in general for eDiscovery. This is not civil litigation between parties. This is really a very discrete type of action, and that the U.S. should have the ability to secure that information, based upon the merits of having a search warrant that was approved by a judge.
A very good point. Well, you brought up the international eDiscovery issue from this, so let's move away from the court opinion and let's talk about managed services for eDiscovery. And why don't we start with David Cochran to share your views on how these goals can be accomplished, and when you have different parties in different countries and the advantages of managed services.
Sure. Thanks, Josh. I think going back to our previous podcast on co-sourcing, I think what this decision and just strategy alone mandates and frankly dictates is that organizations must have the ability to co-locate inside another international country in order to process, to review, to call, to do managed review services there, with the comfort that their data is not going to be subpoenaed by the U.S. necessarily. And so having that co-sourcing and working with a company that has offices in country and being able to do everything there, it really alleviates the pain and the agony of having that cross-border issues that may come up in courts.
Very good. David Holme, your thoughts on this as well? And since you and Planet Data are having a partnership and being able to accomplish eDiscovery together, what are your thoughts?
Well, sort of, I suppose, without taking this latest ruling too far, it's sort of the irony about this is if that reach is extended beyond US boundaries, then so too can the discovery process be extended, if you see what I mean. So from a purely selfish perspective, one of the things that we've come across in the US historically has been, well, the data's overseas, so we can't get at it. Ironically, if you can, that means that the flexibility to do this overseas or in any jurisdiction is freed up. So ironically, this ruling kind of oddly helps us in a funny sort of way. I think that the other issue about this, though, is just the utter paranoia of other jurisdictions to have anything placed anywhere near American soil. This may well again change that. I mean, the constant theme we hear is this sort of massive concern about the discoverability of any data that hits US soil, and nobody can quite figure out what that means. So, oddly enough, this might change that, but certainly to our benefit, I suppose. So it's going to be interesting to see how this plays out. It may mean that ultimately that having a base in the EU makes absolutely no difference whatsoever if the US can actually effectively extend its reach. But as Howard said, it will much will depend on the next round of case with the appeal court, because is this just going to be a criminal case? Yes, no. That said, these criminal cases are going to extend to financial institutions, which is the next big round of discovery, or certainly the current round extending into the future. So, ironically, managed review overseas suddenly looks even more plausible than it did before.
Josh, and I also think that even with this ruling and whatever comes from that over the next months, years, there's still that need, that ability to have in-country processing, in-country review. And I think that's something that law firms, and more specifically the U.S. corporations with affiliates overseas or European, for instance, based corporations, want to have that comfort that their data is still considered private. It's being done, within the jurisdiction of, and their purview in a location that they're comfortable with and not hitting the U.S. And so I think even as this suit goes on, this ruling goes on, the ability to be able to do this type of processing, this type of review, this type of technology there, is going to, drive discovery on a more international basis going forward, not only in the EU, but, as David talked about, in Canada and Australia and, and even Asia.
I think that's right, David. Certainly increasingly Asia is one of the things that's sort of high on our list too, where we can see a significant upswing in activity in places like Singapore, Dubai, UAE, and adopting mainly US practices in terms of data protection. But I think there's always going to be that sort of the next barrier will be the sort of local competence as well as understanding of international regulations. We're a long way from this market being mature, is my view.
No, I totally agree. And I think it also goes back to the expertise in the area. Coming back and having a U.S. company going over and just setting up in the UK, for instance, and just having U.S. based staff, is not always the smartest way. And so, going back to that co-sourcing theme, best of breed, being able to make sure that you've got experts that are in country as well as experts that have process, et cetera, combining, combining operations and going forward is going to give that client a whole lot of comfort in knowing that, number one, what they're asking that organization to do is going to be done properly and correctly, but also knowing, underlying from a security officer that data is secure and that's not going anywhere that they don't want it to go.
I think that's a good point to distinguish, actually, Dave, because it's not just about the court in the New York Second District or whatever it is. It's about those security protocols that sit around that, and that competence to manage that security and that data, regardless of the jurisdictional issues. It's about those base competencies. And I've been traveling in the States, sort of looking at this space intensively for the last 3 or 4 months, and some of the practices we see, or I've seen onshore, have been far from best practice, I think it's fair to say. I think quite often the standards that we've been held to in the past have been way, way in excess of what I'm seeing with some of the kind of multiple onshore vendors. So that question of expertise, competence, and security is actually quite different. You have to be pretty careful about who you're choosing, I think.
Hey guys, I wanted to just weigh in on, so we don't get caught up just on the Microsoft case, which I find to potentially be sort of an outlier. But the kind of discovery, the civil discovery that we're doing, most of these corporations, whether it's David said about financial fraud, those companies are already in U.S. jurisdiction, subject to U.S. jurisdiction. And so they're, basically, I think it's been pretty resolved that if you're in the U.S. doing business here and you're in a civil litigation here, you're going to have to produce some of the data responsive to the discovery request. The real issue comes down to, and one of the reasons, one of many reasons we're establishing this relationship with Exigent, is because while you have to produce the relevant information for the courts, for the other side, most of the European countries now and corporations are very uncomfortable, as we discussed earlier, between the NSA and the Snowden scenario. They just don't want their raw data or their PII coming to the U.S. And so I think it's really critical that you be able to do at a high level of competency, as David said, that you be able to process and review and cull the data down to a very particular purpose for the U.S. litigation, and have that done in the EU without that raw corpus of much larger personal information leaving the EU.
Yeah, let's move ahead and focus a little more on the civil aspect, because that can come in a variety of ways. And there's another issue that we could get to with the UK Bribery Act and the Foreign Corrupt Practices Act, where that can play for both countries doing international business. So let's think about, and we've been talking around this, but the global reach of clients where everything is just not in the United States, but it's all over. And we've talked about this in large part, but looking to David Holme, why do you think that you need to have a service provider in a host nation to comply with the privacy laws as a way to avoid getting into trouble in civil litigation?
Oh, I don't think you do. I think quite the opposite. I think there is absolutely, if you stand back for a second and you look at these various acts in various countries, I can certainly talk for the UK, given I'm currently here, and the US. I think the interpretations of the act are pretty vague right now, but we're a long way from people litigating on it in any serious way. Because of that, I don't actually think you need in-country competence with regard to that from my perspective, and certainly from an Exigent perspective. Law firms will have their own view on whether you need in-country or not. My personal view is those two, well, certainly the Bribery Act, have no impact on where you have to base any kind of litigation or review at all. I haven't heard that as a particular concern from anybody. We have endless sort of experience of people talking to us about different data privacy acts in different jurisdictions, but in most part they're quite similar and allow you a considerable degree of flexibility. I absolutely don't think you need in-country for probably 60 to 80% of the work that's required, where the costs, where the majority of the costs lie. I don't see that, and actually, I don't really see the sort of the Bribery Act or as being inhibitors on that at all. I think that's targeted at something quite different. That's my take on it.
Yeah, I would take a different point of view because I would never advise a U.S. forensic person to go into a European country and do a mirror image of a European hard drive and then leave the country with it. I would not encourage that at all.
Oh, sorry, I misunderstood the question slightly. I think probably Dave Cochran's a better person to answer that, because remember, we're looking at the delivery of managed review globally rather than the actual collection. That's probably outside my pay grade, to be honest. I think that's probably bang in Dave Cochran's field of expertise.
I'm sorry, Josh, go ahead.
Go ahead, Dave.
No, what I was going to say is, I agree with what you were starting to say, Josh, about going in and doing the collection, sending over a U.S., person to do that, having that kind of speciality, to there in country, as well as then, having the ability to house that data, in a data center there, for it to be processed, for it to go through some kind of early case assessment and then manage review, having that data set there, but having it reviewed, for instance, having a managed review provider, like an Exigent, in a South Africa that can access data under the same rules and standards that are acceptable within the EU is, so very important, because in that same example, a group sitting in the U.S. could not access that data, from the U.S. into a data center sitting in Dublin, Ireland, for instance. So, to me, it's a lot of best practice, and it's a lot of, because the other underlying with regard to security is cost. People are, it's very cost adverse. So the ability to be able to apply good security, valid security with low cost alternatives that fit within the security model are so very important. And I think that's the opportunity, in the EU today.
Yeah, I think that's right, Dave. I mean, there's sort of, you sort of have to disaggregate the two things. I think there are a couple of things worth mentioning. The US has definitely got best practice. And we talk rather grandly about the EU, but we're actually really talking about the UK and Ireland. I mean, the idea of doing this in Portugal right now is not massively appealing. So I think, let's just talk about kind of Northern Europe, maybe Germany, UK, Ireland. What Planet Data have, which is US best practice and as good as anywhere you'll find, is this ability to collect in the right manner. I think, with our partnership, we have people locally available to advise on any differences, any significant differences, but actually that phase is, I'd say, pretty consistent. But you do need some local jurisdictional expertise to make sure that there's nothing that we're doing that is, outside sort of best practice in Europe. But I would say best practice in Europe is ill-defined compared to the US. And one of the attractions for us in partnering with Howard and Dave and the guys is, we think that we're sort of linking up with the people who've got the best possible practice in terms of the sort of what you might call phases 1 and 2. But we are aware that there are some jurisdictional challenges. I don't think they're I don't think they're enormous as long as you're pretty smart about it. Dave, do you think that's reasonable?
Totally reasonable, because I think you can get sort of wound around the axle with respect to what can you do, what can't you do, and you begin to lose focus on the practicality and the fundamentals of having a good foundational approach to doing discovery management, regardless of the of the locale. So I think that is a very important component.
Hey guys, I want to just add something on this basis. I had a conversation the other day. I have a federal district court judge who's a good friend of mine, and he was over in London last week at the Sedona Conference on International Cross-Border Discovery. And his one comment, it was only a brief conversation, was that he was actually startled at how involved the DPAs, the Data Protection Authority, people in the various countries would like to get on a case-by-case basis. Kind of supports what David says, and that they're willing to work with you. You just have to work with them and not just not roll over them. But they understand the need for this cross-border data transfer. And they're willing to cooperate with you. And the judge said he was actually surprised that they actually, on a case-by-case basis, wanted to be involved and work with the participants. It's kind of
yeah, I think there's definitely a growing recognition in Europe, and I say I don't mean Portugal or Greece in that actually this is that the data protection legislation is up to date. How it's enforced is very different. Disclosure in sort of Europe, regardless of the US, is going to grow at exponential rates over the next 3 to 5 years. No question at all. I don't think anyone doubts that. And because of that, I think people are waking up to that and thinking, well, the court in the second district is a sideshow. We've all got the same problem, actually, which is disclosure is only going to grow as an issue for us. And so, the more we can think about common rules, so much the better. I mean, there's a growing. I mean, it's great for lawyers, but at the end of the day, a lot of this disclosure work relates to, as Howard said earlier, this sort of these large multinationals with cross-border presences anyway, so it doesn't much matter. Where we're focused is sort of having the best technology with the best partners and the best processes, because at the end of the day, whether we like it or not, we're a small part of the cog in the wheel, and the relevant authorities will make their own minds up about, what the restrictions are in terms of data transfer, and we will comply with them, provided we've prepared expertise in the right areas and we can demonstrate that. That's the critical bit. We can't influence the legislation on this, and of course we can't. We've just got to be adept enough to change our approach as and when necessary, I think.
What you're all discussing is project management in different forms in 2 different countries, trying to achieve the same goal, responding to a discovery request, whatever the European equivalents to them for disclosure. So I think that's the eyes on the prize that we need to talk about. And Howard, could you share your point of view on how both of you would work together for effective project management for an international eDiscovery issue?
I want to turn that one over to Dave, because that is really his expertise, and he is the one that is driving the workflow and the project management between the 2 companies. Yeah, Dave.
Sure, thanks. Josh, I think that's very important. I mean, one of the themes that we've talked on previous podcasts, not only co-sourcing, but just in project management in general. And I think, that's why I think Planet Data and Exigent work so well together, because, I always go back to the foundation. I'm pretty boring when I talk about that, but both organizations have very strong project management foundations. And frankly, that's going to be the success of, doing disclosure in the UK as we're proposing and implementing with the same, the same reporting, the same communication, the same technology. It's all very important, so you have consistent application. So at the end of the day, when, regardless if you're working for corporate legal or you're working for a big city firm in London, that they understand and they're comfortable that what they asked you to do, you did it right, and you can validate it it goes back to chain of custody and everything that we talk about in the U.S. is being implemented in the EU, and as David mentioned specifically, the UK, Ireland, Northern Europe, especially. So, very confident that all of those procedures are already in place going forward.
I think that's right. I mean, I think it's sort of an interesting one because some of the disciplines that Planet Data have, we could never hope to learn, and which are super important and industry best practice. I think, and we've been working with them for a while out of our India office for the sort of the ESI piece, where we have sort of joint best practice. The bit that we've added on really is the review, multilingual review piece in Cape Town, and we, the principles we apply are obviously statistical analysis and QA, and Six Sigma kind of processes. Now, where we differentiate from maybe one or two of the others is in our kind of Cape Town facility, we don't need to slavishly follow every process to get the right result, because at the end of the day, you'll find that most projects they extend, they get more complicated, and end-to-end, point-to-point process is not the be-all and end-all. For certain aspects of a litigation cycle, those are important, and you need to understand the value of process. For us, more important is the statistical analysis of accuracy and delivery, all of which is out there, and we probably more slavishly follow statistical analysis of productivity and accuracy based on principles like normal distribution analysis than we do kind of by almost signing up to saying, well, we do some Six Sigma, but we don't really know what it means. So we're quite different in that sense, I think. But the disciplines across the end-to-end part of the process vary, and that's why we can't and don't want to kind of understand those Planet Data processes because they're the best in class, and the same with us. And that's really why we came together on that, I think.
Well, we have ILTA coming up, and I know you both will be at ILTA together. And I would encourage folks interested in learning more about international eDiscovery and the partnership that you have together and providing solutions, that people visit your booth at ILTA. And to learn more about where you will be at ILTA and perhaps schedule an appointment and being able to visit, I would encourage people to check out Exigent Group, their website. So that's exigent-group.com/events, and visit them at ILTA, drop them a note, and see what you could learn from their expertise, because these are very smart folks who understand how to do eDiscovery on both sides of the planet. So with that, everyone, I want to thank you for your time and being able to discuss international eDiscovery issues, and I hope everyone has a wonderful time at ILTA. Thank you, Howard, David, and David.
Cheers.